Hi, my name is Rebecca Spohr, Sales and Partnership Manager for Rome Migration Law. Welcome to our first ever Hot Topics legal podcast presented by Rome Migration Law. Hot Legal Topics podcast will cover one-off topical developments to ensure that you're up to date with significant changes in law and practice. They will be delivered by experts in specific areas of employment, immigration, and family law. It's my absolute pleasure to introduce our first guest, Mr. George Harros, partner at Gadens. George practices in employment, industrial relations, commercial and property law, particularly with respect to disputes arising in these areas. George offers industry-specific knowledge in a number of areas, including professional services, construction, technology, sport, transport, manufacturing, security and hospitality. Gadens is a leading Australia law firm with 97 partners, 880 employers across offices located in Adelaide, Brisbane, Melbourne, Perth and Sydney. Hi George, it's great to have you here.
Thanks Rebecca, thanks very much for having me. It's a real honour.
So this morning we'll be discussing hot legal topics in employment law. Could you tell me what the hottest thing is at the moment?
Well, when you talk about hot things in employment law, I suppose over the last few years it's been a very, very busy time for us and employment lawyers, and I think lawyers generally, which a lot of people probably don't like to hear, but we have been incredibly busy. And when you come to employment and industrial relations, some of the things that are keeping us particularly busy and hot, I suppose you can't go past the sexual harassment rises in the workforce, and especially since I think people have come back to work. We can't really put our finger on why that is the case, but perhaps it's the fact that people aren't getting their pre-seasons in when they're coming back to work social events, and they've just lost a little bit of that touch when it comes to how to interact with their staff. So that's certainly been big, and it comes off the back of the Respect at Work project that was undertaken by Kate Jenkins a few years ago, and there's going to be more and more implementation of those findings into Australian workplaces under the Albanese government. So yeah, certainly sexual harassment's still a big issue. Some other hot areas for us, I suppose, continue to see rises in unfair dismissal and general protections claims. So the Fair Work Commission is really busy dealing with those. There was a lot of activity stemming from vaccinations that weren't really successful, but now we're finding that in that area, probably getting people back to work is really very topical at the moment, and we're sensing a bit of a silent war that's ongoing between employers who want people back to work but are a little bit nervous about saying so because they're concerned about cultural impact and people leaving, and employees that have become pretty comfortable about working from home and enjoying that balance and the benefits they get from that. So there's a bit of tension in that space, and I think we'll see more and more activity flowing through that. I think employers are going to slowly become a bit more aggressive in their demands to get people back to work.
So the tables are turning then?
Starting to turn a little bit, but the other side of the coin is that we're in a really tight labour market where everyone wants the best talent, and we'll talk about that a bit more in a moment, but the tables are turning a bit. I think employers are starting to come to the end of their tether in some respects.
We're gaining a little bit of the power back again, it seems.
Perhaps, although it's a pretty good market for employees, and there's some good sign-on bonuses and things like that. So, people aren't scared to probably look around. We heard about the Great Resignation in the US, and maybe that's on our doorstep. Not too sure. I don't think we've seen it in Australia yet, but could be something we see. Another area is really busy at the moment for us is enterprise bargaining and industrial relations. So seeing a lot more union activity, seeing unions really stepping it up in terms of trying to implement their foothold on different organisations and negotiate enterprise agreements. So that's really, I think, rebounding quite strongly under the new Albanese government, and I think there'll be more and more of that activity. Work cover claims are on the rise. No one really likes to hear that, particularly in the area of mental health. A lot of people quite stressed and have a lot of anxiety about the return to work, but also just, I think, a bit of sense of just this stressful environment that we're in, a little bit of uncertainty. We have a lot of difficult factors just in our environment. Inflation's at an all-time high.
Yes.
It's just causing people tension. So we're seeing a number of work cover claims as well. The other area that I think we're pretty busy at the moment is in relation to Fair Work Ombudsman investigations into underpayments.
Wow.
So I think we're going to see more and more of that. It's probably just a matter of resourcing for the Ombudsman. I think if they had more people and probably more money to investigate, we'd see more investigations. So, there's some of the really busy areas in employment law. We really are it's a really busy area of law, and good employment lawyers are pretty in demand at the moment, which is good for us, but I'm sure a lot of people watching don't like to hear that. And I suppose the other area which we're going to focus on a bit more today is employers really taking some stronger steps and actions with respect to enforcing post-employment obligations.
Okay.
So when I'm talking about post-employment obligations, I'm talking largely about protection of confidential information.
Yes.
Going to work for a competitor or setting up their own business in competition with their former employer.
Okay.
Poaching employees from their former workplace, or trying to solicit clients and customers of their previous organisation. And we'll get into that in a bit more detail, I'm sure, but that really is one of the hottest areas for us at the moment.
Go a little bit further with that topic and the things that you've been experiencing.
Yeah, sure. Well, I think that the starting position is that restraints of trade and post-employment obligations, these aren't new concepts, and they're concepts that employers have had in their contracts or should have had in their contracts for a long period of time. But what we're now seeing is a little bit of a shift in some of the courts' decision-making in that respect. So we're seeing courts enforce restraints of trade obligations more frequently. And we're also seeing a real shift by employers. So traditionally, some employers may have sent a nasty letter to try and protect themselves and try and put a bit of fear in the eyes of the employee who has left. But now we're seeing that being taken a bit further. So it's not just a letter, action is actually being taken. So that's the first thing. And then when you tie that in with the point I made previously about the courts enforcing these, you're getting a situation where employees really need to think twice before they either move to the competitor or poach an employee or solicit a customer, which are the really big factors. So, that's really what we're seeing in the market. The other thing we're seeing is probably the lengthening of notice periods.
Okay.
So traditionally, it's pretty common in Australia to have a 1-month notice period, and some executives up to, say, 3 months. Now we're seeing those really sought after roles such as sales and general managers and people that have strong client-facing and holders of information and confidential information having 3 months, 6 months, and sometimes even 9-month notice period. And that can really help the employer who has just been, the employee's just left, because they get to either hold on to that person or put them on gardening leave or have them in some other function that's not client-facing during their notice period. So it gives that's really one of the best forms of restraint you can get.
Yep.
And I actually think it can be a bit of a deterrent to someone if they're trying to, a new employer is trying to entice them to get across. If they know that there's a lengthy notice period, they might not be as enthused as they were.
Oh, I agree 100%.
Yeah, so I think there's some of the factors and some of the things we're really seeing in the shift in the dynamic.
But you can really see why employers are doing this though, George, with such a shortage in the skilled workers at the moment in Australia, but it's a global problem at the moment. It's the best way to protect their asset, by extending that period 6 months or 9 months.
Yep.
You're stopping the person from going potentially being poached by a competitor, stealing any of your clients, but also having them there not to move for that period as well, and being able to
Indeed.
fill that role.
Yep.
So I see it as it's a smart move by the employer, I believe, in regards to changing those things within a contract.
It is, and look, I think it's really important just for people that are viewing to know that when it comes to drafting your contracts, it's really important that you have clauses in there that allow you to put people on gardening leave.
Great.
Because unless there's a clause in there, you can be, and you try and put someone on gardening leave when you don't have that ability under your contract, it can cause you issues with the enforcement of your restraint clauses. It can be considered what we call a repudiation of the contract if you try and change someone's work in such a dramatic way and you don't have that ability. And the other important aspects of a contract that people should be aware of, that unless you have a restraint clause in your contract, then there is no restraint. You cannot stop someone from working for a customer or client, or poaching staff, or poaching or soliciting clients if there is no starting position in the contract. You can't, quite often I'll have people come and see me and say, so-and-so left, they're my key salesperson, they've gone to work for a competitor, I need you to do something about it.
And they can't do anything.
And if there's nothing in the contract, there's nothing they can do. Confidential information is a little bit different. You do not need to have a confidential information clause in your contract to protect confidential information.
Okay.
There are implied duties with respect to confidential information, and also requirements and obligations under the Corporations Act that give employers protection when it comes to confidential information. So sometimes when someone is leaving an organisation, the disgruntled former employer will try and rely on confidential information as a way to try and curtail the behaviour of the employee, particularly if there's no restraint clause, or sometimes there's no contract at all, which can cause even further issues for that former employer.
And so what would be your biggest advice? Because obviously we're talking about almost protecting, the employer at the moment.
Yes, we are.
But say if, someone like me in my position
Yes.
decided that, I wanted a new role, what would the advice be that you would give me in regards to what I would have to look out for in my employment contract to make sure that I was protected? But not only that, setting me up for the best success without obviously, upsetting anyone too much with my demands.
Sure. Well, I think the starting position is you need to ensure that you have a professional look at your obligations.
Great.
So let's look at it from a perspective of you're working at an organisation and you want to leave and go and work for someone else.
Yes.
So you want to have a look to see whether A, you have any restraint obligations.
Yes.
And if you do, whether or not they're enforceable, and have that assessed. Now, if there is some uncertainty about the enforceability provisions of those restraint clauses, you might want to try and negotiate an outcome with your existing employer.
Yes.
To see whether you might be able to find some middle ground and say, look, I don't know whether this is actually going to be enforceable, but I'm happy to not approach any clients for a period of time in return for you allowing me to go and work for company X immediately.
Great.
And try and find a bit of balance between them, so it gives them some certainty, but it still allows you to go and work somewhere else without too much concern.
No, that's really good advice. Thank you. George, while you're talking about employment agreements, what are some of the other important aspects in an employer's contract that people need to be aware of?
Yeah, well, I think the starting point with that is it's really important that you have employment contracts to start with, because in absence of an employment contract can cause you a lot of issues, and also doesn't really set the parameters for the employment relationship to proceed. One of the bigger issues in not having an employment contract, though, is that in relation to notice periods and employees not knowing how long or how much notice they need to provide.
Yeah.
And if there was to be a termination, then sometimes the employee might argue that they're entitled to reasonable notice.
Okay.
In some circumstances where you have an older employee or someone who's worked with you for a long period of time, maybe in a specific industry where it might be hard to get another job, there can be arguments that the notice period is longer than, say, 3, 6, 9, 12 months, and sometimes can even be 24 months if there's some real difficulty for that person to be re-employed. So having a contract to start with is very important, and for the reason of the restraint clauses that I talked about earlier, because in the absence of that clause, you really don't have anything in that respect other than reliance on confidential information. Another important aspect is relating to defining what is confidential and what is intellectual property. Notice periods, again, making sure you specify them. Also, we see a lot of issues when it comes to commissions and bonus payments and how they're structured.
Okay.
So your contract should ideally refer to a commission or sales policy, which should sit outside the terms of the contract, but be really clear about what does the what and when does the commission payments, when do they get paid, how are they calculated, what are the key metrics, really tangible aspects.
Having it all spelled out.
Have it all spelled out. What are the percentages? If the employee resigns before the bonus is paid, are they still entitled to it? If they resign partway through the year, are they entitled to pro rata payment of commission and bonuses? We see a lot of grey in this area, which usually leads to a bit of disputation when it comes to commissions and bonus payments. The other thing while we're talking about restraints is it might be worthwhile, or it usually is worthwhile, to have in your contract a warranty by the employee who's joining you that they aren't bound by any former restraints from their previous employer, and that they have had that properly considered, so that you as a new employer can't be roped into any allegations of encouraging or inducing the employee to join you in breach of obligations that they owe to their old boss. So some of these things are really important and usually can be found in employment contracts drafted by reputable lawyers.
Thank you so much, George. This is our first episode of Hot Legal Topics. I'm really appreciative to have you, but also to use your wonderful office today. So thank you to Gadens as well. Really looking forward to seeing George in a few weeks' time. As I said, this is a series with leading experts in different specific areas of law. Thank you again for joining us, and we look forward to seeing you next time. See you later.
Thank you.